everyone, welcome back to Litigation Help. My name is Heather. Joining me today is Eva and Laura, and we're going to be talking about the role of the mediator. So what does the mediator do exactly? How do you guys create this magic of people coming to agreements?
Yeah, sure. So Laura and I often work in family mediation. So we're working with families who are going through separation and divorce. And Laura and I practice what's called co-mediation. So that means that we're both mediators at the table. So our families have two mediators with different backgrounds. And what we're meant to do, or what our purpose there, is to just help them negotiate the issues for their settlement. Eventually, once everything is done, we're going to create a contract for them called the separation agreement. That separation agreement is going to outline everything: custody, child support, spousal support if those apply, property division, and all of that. And so we're helping them negotiate all of those. So we're neutral, we're unbiased, we're at the table.
So I'm just wondering, I know that people tell me that one of the greatest things about mediation is that you're able to think outside the box. Can you sort of explain that to me a little bit more?
Sure. So it is a very creative process. And the way that it is structured to be creative in terms of what practical options. Sometimes in the court you may never get to the practical options because you do not have that type of space that we can create for the families. So we get to that type of generating of options together through ensuring that there is a safe environment, first of all, for the parties to share. So to be free and feeling good enough to share some of their options. There's never any attachment, so we ask people to not feel very attached to any options that they generate. It's all just about generating options and practical ones. Sometimes we also offer, with their permission, we offer other options that they may fit within their schema over there, and that's very beneficial because that's also guidance and information that we provide during this process. We identify their issues, the relevant issues, and then we also add to some of the issues that they may have to think.
They may not have thought of it.
They may not have thought, and that's the reality of things. That you can't, rightfully so, you can't think of everything that you need to be thinking of in terms of consequences, in terms of what needs to be clarified in a separation agreement, what needs to be clarified at the table, things like that. So we are equipped to ask follow-up questions, to provide that type of environment, to clarify issues, to clarify some of underlying issues that it may be present at the table in a conflict. So we are qualified to work with that. That's kind of the role of a mediator, to identify the issues, provide an environment where the parties are feeling free to express themselves, and then work with their issues to create options that may fit their family's needs.
Sort of like a safe environment so that they're able to express.
Safety is very important.
Okay. Absolutely.
That's really interesting. But now, sort of a side sort of tangent to that is, did you guys ever have to be referees? Because I know that in real life, right?
You know what? Oftentimes with family mediations, sometimes the discussions can get a little emotional. Sometimes they can get heated, and that's what Laura and I are there for. We're there to make sure that things stay productive, and that the family can walk away from the table with less or not as much damage to the relationship as they would if they had gone to court or they're having the fight on their own. So oftentimes families will come to us and say, you know what, this was a hard topic, we couldn't talk about it at home, so we had to talk about it here. And that's fine because we can keep the conversation going. It's important that everybody has a voice, everybody shares their opinion, but they can do so in a way that neutralizes the conflict, that doesn't have to, raise, loud voices or name calling. We can avoid that type of stuff.
And that's really interesting because it's, I think, hard for people to imagine that, like, when they're at home, in the privacy of their home, sometimes the communication gets kind of wonky. It gets really bad, and they're not really able to. So with the help of a mediator, parties are actually able to be more sort of civil to each other. Is that how it kind of works?
Yes, and you know what, and it's a step up even beyond civil. Is they're able to actually. We are able to sort of manage the emotional baggage and move forward into a more productive discussion. So it's not just the voices or the blaming, the shaming is lessened a little bit, but they can move now further into a discussion based on how we are able to reframe some of the issues at the table and work with them, right? So it's not they can do more. They can be much more productive.
And I know that I think one time you told me that if things really go out of hand, you do have the option to terminate the session.
Absolutely,
okay.
Absolutely. We can terminate the session. They can terminate the sessions. We can take a break. We can move in separate rooms, and that's what often happens. Because rightfully so. I mean, it's an emotional process. It's okay to have emotions at the table, and we call that out as well. Like we would not be allowing a forum where the escalation of conflict may hinder or damage the relationship or create negative, sort of like consequences. So we would stop it. We would either, and in the worst case scenario, we would also terminate. We can get to terminating, withdrawing from the mediation altogether. So if we sense, and that goes back to that, ongoing monitoring. If we sense that someone is using the process or abusing the process to benefit only themselves, then we would call it out, and we would say this is not the forum. We're here impartially for both of you.
Okay.
So if we sense that, then we properly give a warning, and if the warning is not followed, then we would withdraw from the mediation, because what we don't want to be, we don't want to be a forum where more harm than good occurs, right? So we want to make sure that if they are engaged in this type of process, there is obviously better than worse what comes out of it.
So one last burning question. If one spouse, let's say, puts an offer on the table that is way below what the law entitles, do you say something?
That's a really good point. It's a very fine line for mediators to judge offers, especially because we can't give legal advice.
Right.
That being said, oftentimes what we do is we ask people to justify their positions, right? So we do make sure that everybody at the table understands the law.
Right.
We make sure they understand what they're entitled to, and we make sure that everybody is basing any numbers they bring to the table with source documents. So you can't just come to the table and make something up. Right.
That's what I'm afraid of.
People that doesn't happen. We do have a process where everybody knows exactly what they're entitled to. So if it is a lowball offer, there should be a reason for that, and we talk about that. We also always do encourage legal advice. So someone, if they are afraid that they don't have enough support or they're not sure to make what decision to make, they can talk to a lawyer and then come back to the session. They don't have to accept something right away.
That's so good to know. I mean, that actually, it's so safe, actually, isn't it? This process. It's not like court where there's all these deadlines and if you miss it.
No, not at all. And if anything, oftentimes people go to court unrepresented.
Yes.
So that means that they're in the driver's seat of their court case, and everything is on them to make sure that they present the law and the evidence correctly.
Right.
But it is impossible. It's very difficult to do for lawyers, let alone for someone who's unrepresented. At the mediation table, you are in the driver's seat, but you have support, you have information, we do divorce mate software. We have the divorce mate software, so we have the printouts for child support, spousal support.
Right.
We help people navigate the values of their homes and how to organize their debt. So you have a lot of support at the table.
Oh wow, that's amazing. Laura, did you want to add?
Well, to finance, we feel that wherever there is financial negotiation, then there has to be full financial transparency.
Right.
So that's a big factor that is present in the mediation process. It's full financial disclosure.
Right.
Financial forms, everything are being completed, and we help them navigate and complete those forms and then reorganize their financial stuff according to their needs. But everybody will have access to the numbers, which we think is very important.
Are these the court forms that are provided by the court, right? So they can
they're the same forms.
Right.
Yeah.
So a party cannot say, "Oh, I'm going to make my own forms."
No. No. We all use the same forms.
Oh, okay, that's good to know. Well, thanks very much for this video. Thank you very much for watching. If you want more information, don't forget to check the links below in the description. And see you at the next video. Bye.